Now, there's a lot of talk going around that Diddy wants to be released on appeal, that he wants to have an appeal bond issued pending his appeal. He thinks that somehow he can have this thing done. Well, what does old Diddy have to do? What does he have to show? And what are the various standards for him to indicate in order to accomplish such? These are very, very good questions. Remember, ask the questions. Now, remember something. When a defendant appeals a conviction, he's already been convicted, hence the term, and he asks for a bond or for bail pending appeal. What he says, remember, everything he was acquitted of everything except that I think 2 counts of transporting hookers. How do you like that, ladies? You're hookers. You're adjudicated hookers, but transporting them across state lines. If he says, I want to appeal that may be years from now. I want to be out while that's, being decided. Courts apply strict standards and far more rigorous than pretrial release. See, the burden shifts dramatically. You're no longer presumed innocent. You've been convicted. This is what's critical about this. So now the court has to decide whether you're worth the gamble, so to speak. So here are the standards, and here are the factors that a court would decide whether to release Diddy, and when determining whether to grant an appellate bond or an appeal bond or a bail pending appeal, whatever you want to call it. This is, by the way, this goes for both federal and state cases. First, number one, you have to look at is there a substantial question of law or fact. The appeal that you're bringing must raise a substantial question, meaning if it's a close call, not frivolous, if it's kind of an interesting case, and it could result in reversal, a new trial, or reduced sentence. You want something that's not absolutely a no chance win, but something where you think, you know what, you got an interesting thing here. There's a substantial question. This is a pretty good question here. The translation is you just can't say, Judge, this was mean, or I want some time off, or I've spent enough time in there. Why not just let me out and then, after a couple of years and put me back in afterwards? No, because he's been convicted. You have to raise a legitimate legal argument, like improper jury instructions or prosecutorial misconduct or ineffective assistance of counsel or something. Now, the second criterion, he can't be a danger to the community. You've heard this before. The court has to determine and be convinced that releasing him wouldn't put the public in harm's way, won't lead to further crimes, especially violent or obstructive issues, especially pending, witnesses and the like. Even if your legal argument is solid, if you're deemed dangerous, they say, forget about it. It's over. Not interested at all. So next, third element, can't be a flight risk. The court will ask, do you have ties to the community? Do you have a history of skipping court? Do you have the resources to flee? If you're wealthy and you're facing a long sentence, or if you've got foreign ties, that can work against you. The next one, number 4, the appeal is not for delay. This is critical. If the judge finds or thinks that you're filing a bogus appeal just to buy time before serving your sentence, the bond request will be denied. The appeal must be in good faith, with a genuine intent to challenge the conviction, not delay justice. And going back to that first one, there has to be a substantial issue. Number 5, you've got to show clear and convincing evidence, that which I've suggested before. In federal court, under 18 U.S.C. 3143, after conviction and pending appeal, you've got to show that the default is that you go to prison, and that the burden is on you to prove all of the evidence mentioned clearly and convincingly. It's a high bar. You've got to show all the following: substantial questions, not a risk, not for the purposes of delay. And there's different standards in state and in federal. But here's what you got to remember, too. This is very, very critical, and I want you to think about this. Diddy's got to be very careful. I've been hearing some people suggesting that some of the stuff that he's saying, some of the stuff that's being written, some of the stuff that's being posted, some of the stuff that's being provided for in terms of social media platforms might be construed by some as being a little bit not risque, but kind of almost threatening in a weird way. Almost threatening. It's a very kind of a scary thing here. And you ask the question, is this something that, how do I say this? Is this something that he is this the right message he's giving out? What I mean by that is simply this. Let's say, for example, that somebody says, Mr. Diddy, we were thinking about letting you go, but these signals. See, that's that thug part of him. He wants to be Suge Knight. He wants deep down inside to be a Suge Knight. He wants to be Suge, and he wants to be, and he's looking at all these aspects. And what's also interesting to note, which I find fascinating, is that there are a lot of people who really are afraid. Now, my question always has been, and I would tell the court, look, if he wants to off people, he could do it inside or out. Diddy's not going to do it himself. But if he wanted to get the message out, one could argue that he could do this on his own. Now, my prediction is they're not going to let him go. He's going to stay there until the appeal is heard. Every day he stays in jail, waiting for prison, it's credit for time served. So if he does 8, he's going to do like 18 months, maybe 20 months, year and a half, something like that. It's going to be de minimis. He should just sit back and just wait, so that when the appeal is heard, he will have already served his sentence. So, hell, he's been there the whole time. Build up his cred so that he walks out free and clean. Done. No probation, no post-trial restrictions, no nothing. This is the luckiest man in the world. And one more thing, Diddy. Lay off any comments about Ghislaine Maxwell. Do not get involved in it. Do not be questioned. Do not take yourself out of that those crosshairs, because you, my friend, are going to lose. Okay? What do you think? You think he's got a chance? Or is it over for him? I know you may not be a lawyer, but what's your take? How do you think he was treated? Was he treated fairly? Do you think in retrospect it was nothing? Do you think that these 2 charges were just a concession? Do me a favor, like this video, subscribe to the channel, hit that little bell so you're notified of live streams and new videos. Make sure you also follow the questions which I provided for you. And above all, dear friends, and I can't say subscribe. 80% of the people who watch us don't subscribe. I don't know why. But more importantly, comment as you see fit.